All right. Good morning, everybody. We've got a big group already in. I think a few more people still trickling in, but it's our pleasure to host the webinar this morning with Burr Forman. First off, just want to introduce myself. I am Carolyn Davis. I work as manager of events and outreach for the Tennessee Chamber, and just want to go over a few housekeeping items and then pass it over to Susie, who's going to introduce our speaker for the day. This platform is Zoom webinar, so very similar to Zoom meeting, which I think we have all Zoomed and Zoomed many times, especially since March. But the functionality as far as the chat box works the same as meeting, so you're welcome to send anything in the chat box. If you do have questions throughout today's presentation, you're welcome. You can send those in the chat. There is also another feature that's a Q&A box, and you're welcome to click that and can submit a question through there. So our team with the Chamber will keep an eye on both of those and be happy to ask questions aloud once Emily is done today. And with that, I'm going to pass it over to Susie Lusk and let her introduce Emily.
Hi, thanks, Carolyn. I'm Susie Lusk, Vice President of Events and External Affairs with the Tennessee Chamber. Thank you all for joining us this Monday morning on this hot topic. We really appreciate our member Burr Forman and Daniel Smith for coordinating this offering today. Our presenter is Emily Mack, and I will read her bio. Emily Mack is a partner in Burr Forman's Labor and Employment Practice Group, where she devotes a significant portion of her practice to helping businesses navigate and resolve day-to-day employment law issues. She has extensive experience assisting businesses and individuals with issues unique to the employment law arena, including matters involving wrongful discharge, retaliation, discrimination, harassment, and hostile work environment claims arising from a variety of laws, including Title VII of the Civil Rights Act, the American with Disabilities Act, the Age Discrimination and Employment Act, the Family and Medical Leave Act, the Tennessee Human Rights Act, and the Fair Labor Standards Act. Emily also regularly counsels businesses on issues involving employee discipline, workplace investigations, leaves of absence, terminations, and wage and hour compliance. She helps clients avoid employment compliance issues by drafting employment agreements, severance agreements, non-competes, and employee handbooks and policies, and conducts in-depth training for clients on state and federal regulations. I will turn it over to Emily Mack. Thank you so much for joining today.
Thank you, Susie. Happy to be here. As Carolyn kind of prefaced, we're going to be talking today about some of the pitfalls and legal risks that are associated, with COVID-19. And I'm sure that many of you have already attended some webinars on these topics, but we are finding that the guidance that's coming out is changing so rapidly that it's really important to stay tuned in. And you'll see there are a few areas where I've noted, explicitly in this PowerPoint even that the guidance I'm giving is based on the guidance that is come out as of not even today, but yesterday, because yesterday was the last time that I had to actually look at this and check this stuff out. So thank you for joining today. And, as there are changes, or if there has been changes in kind of past guidance, I will try to point out where those areas are. Please submit questions if you have them, and we will get to all of those. If I don't get to a question for some reason, my email address is here, and I'm happy to answer that question for you. Just shoot me an email. Just a little bit of background on Burr Forman. We are a regional law firm primarily located in the Southeast. We have about 360 attorneys and 19 offices. I am located in the Nashville office and will be focusing on Tennessee-related issues today. And so where I'm going to start with here is just kind of going over some of the best practices for the office, okay? As businesses, we are managing a lot of different types of risk right now, whether that's from a customer standpoint or business relations standpoint. But I think we're going to find, and I might be biased here, but given what I do, a lot of this risk is centering around our employees. And how do we make sure that our workplace is safe? How do we handle screening procedures? How do we handle workplace exposure? Because if that has not happened for you yet, it is not a matter of if, but when it happens, that we're going to have something that we need to address there. And then I'm going to transition to talking about some of the new legislation out there on mandatory leave, and then how do we handle accommodating individuals who are unable to return to work, who are fearful of returning to work, who simply don't want to return to work. How do we deal with those issues? So I'm going to touch on kind of some broader issues, that you may be experiencing with visitors or customers, but kind of focusing on our employees here for purposes of today. And then finally, I will talk briefly about some of the issues on the horizon. If there is going to be liability, where do we think you're going to see it? Because that also, these best practices, again, are geared at avoiding litigation and risk. So if you haven't, many businesses have been working from home, since March to a large extent. Others are starting to kind of adopt a phased-in approach, for how do we come back to work? How do we bring our employees back? And I think the specifics of those plans are going to vary widely based on the type of business you are, how many employees you have, the capability for remote work. Many businesses are fortunate enough to be able to be almost entirely remote right now. And when they hear about what is going to be required to bring people back, they are happy to just say, we don't even want to see anyone until January, because it is going to be something that needs to be monitored, something we need to be making sure that we are constantly going back to those policies and tweaking them where it's needed, updating them to reflect new guidance. This is not going to be a put it in place and then do nothing type of approach. In addition to kind of cleaning measures, we need to think about screening procedures, PPE for public-facing roles and customers or employees who are working in close proximity to one another. And so if you are one of those businesses that's been doing that, then you likely already have a plan in place. But if you are someone who's considering reopening, these are the things that we need to be thinking about. We've talked, I'm sure you've heard a lot about, things like plexiglass, separations, and requiring now, of course, in Davidson County, we are required to wear face masks if we're going to be in areas where other employees even are present. But some of the other things to think about here are just general policies around things like meetings, things like, and you're going to understand the reason for that when I talk a little bit more about what we have to do if we do have someone where there's a possible workplace exposure. And it's important to think, I think, when you're developing your return to work plan and your return to work procedures, starting with what's going to happen and what are we going to have to do if someone does have a confirmed case of COVID, is going to be important to keep in mind when we're thinking about things like, well, do we allow employees in the lunchroom? Do we allow people to use conference rooms? Do we require, do we require all of those meetings, to be done remotely still? Because the reality is, if we do have someone who has a confirmed case, then every person who was within 6 feet or less from that individual for 15 minutes or more is going to have to be quarantined for a minimum of 14 days. So you want to avoid, we had a client with a manager who went to multiple different site locations, and that was typical for him to do, but it ended up resulting in, when he had, was positive with COVID, we had to send almost the entire workforce home. So you got to think about that stuff, those modifying someone's routine job duties or responsibilities. Maybe it's not a good idea for individuals to be going into different locations if you have more than one location right now. Try to stick to one, try to minimize those in-person close contacts so that, when this occurs, you're not stuck with that. Another thing you got to do and think about too is designating a point person for this. And that is going to depend on, I think, the area. If we're talking about cleaning and disinfecting, is it a maintenance person, an operations person? If we're talking about leave or an employee who's saying, I can't come in, because my child has COVID or my husband, you don't want, in many cases, it's best to try to route those to one designated point person, and doing so, make sure that our response to this stuff is consistent. And that is key to managing risk from an employment standpoint, is knowing that we don't have, people responding differently to similarly situated employees in situations. So, designating that point person, training your supervisors on these policies that we're going to be talking about, and then also letting those supervisors know who is the point person, who is the go-to for cleaning, who is the go-to for leave issues, who is the go-to, for visitor policies and things like that, so that you can manage those things. Some of your policies that you're going to want to take a look at would be leaves of absence, your paid time off, telecommuting. If you don't have a telecommuting policy, now might be a good time to consider adopting one, because I think by the end of this presentation, you're going to know that really the best way to manage risk in a lot of ways would be to allow individuals to telecommute when they can. It avoids some paid leave obligations if they're able to telework. It also avoids any risk of those individuals coming into the workplace and having an outbreak or some type of exposure occur. Again, this is going to vary. What works best for you and what is appropriate for you is going to vary based on your business, but these are just some things to keep in mind. I also have here that providing notice to employees of any new policies and procedures is critical here. I'm sure some of you have found that your employees are stressed, they are anxious, everyone's mental health is strained right now. And so from an employer standpoint, communication becomes even more important now than ever. Employees are generally okay with things, a screening procedure. Say you're going to check temperatures and you're going to have a health screening that asks them about their COVID symptoms. They're generally going to be okay with that. But having notice of it goes a long way, instead of just them showing up for work and as of today, here's what we're doing. People like to have advance notice of those types of things when we can give it. And so I would encourage you to also remember that. So in terms of safety measures, I'll talk a little bit about these. OSHA, if you haven't gone to their site lately, has divided these job tasks into basically 4 exposure levels: very high, medium, and low. Very high is essentially going to be our healthcare workers, individuals who are day in and day out actually working, treating individuals with confirmed cases of COVID. So their risk of being exposed to it is quite high. Most workers fall into either a low or medium exposure risk category, and that's based on really kind of interference with the interface with the public, proximity. If you're on an assembly line or in a manufacturing facility, you're going to be working in close proximity to others, and that will may put you into the medium risk category. And so what we need to think about from an OSHA standpoint, every employer has this general safety obligation to make sure that it provides us a safe work environment and appropriate personal protective equipment for the job. Now, you'll see when I'm talking about PPE and when I'm talking about face coverings, those are 2 different scenarios. The CDC does not consider just a simple cloth face mask to be PPE. A PPE would be a respirator, the N95 respirator, and there are certain jobs that require those. And if you have a business that does require that type of PPE, you probably know who you are. But for me, the OSHA, where it's coming into play now with COVID, is that a lot of employers that are just kind of professional services industries that don't see a lot of workplace injuries, we don't do safety trainings, this stuff still applies to us. And so now we're having to think about it in a different way. So again, minimizing the number of employees, thinking about, are we going to allow customers right now? Are we going to, and to the extent we can, are we going to instead offer telehealth visits, video conferences, phone calls, things like that are good to think about. Staggering schedules is another one where if we can do that and have some flexibility with it. I know a lot of the law firms in town are rotating the schedule for support staff. So not every support staff is in the building at one time. Instead, they're operating on these staggered schedules where they're coming in some days, working from home some days. And then, of course, adding physical barriers is another way to, to create some enhanced safety measure. For screening, again, if you're certain types of businesses in Davidson County, restaurants, et cetera, you're required to be doing this. Schools are going to be required to start doing this if and when different school districts begin going back. And so when you're thinking about screening employees, some of the things we need to keep in mind is that generally speaking, this type of questioning or doing temperature checks would not be okay for current employees unless it's job related and consistent with a business necessity. These are considered medical examinations under the Americans with Disabilities Act. Of course, that's in a normal world. Right now, we are living in a COVID world, so it's okay. The EEOC has told us that it's okay to subject employees to these types of questions, but you've got to be careful about how you go about it. First, you want to be following CDC guidance on what is a COVID-19 symptom. Again, as many of us know, that list has grown and grown as we learn more about the virus, and I expect that it will continue to. So I think periodically checking in with what the CDC has on its website as symptoms and following that and not going outside the bounds of it, right? This is one of those areas where I love to tell employers, we don't want to know about our employees' health information if we can. If we can avoid it. So you really want to avoid open-ended questions. How are you feeling? Next thing you know, you've elicited something. Someone tells you, they're having panic attacks, and that now we know something that we might have to accommodate that relates to emotional health and has nothing to do with what we were screening the employees about, which really is symptoms or signs of COVID-19. So if you're going to do this, use a questionnaire, follow what the CDC says. And I'm sure there's some good forms now that you can use to kind of help guide you with that. Body temperature is another thing. If we're going to be measuring body temperature, which in some places is required, then the best practice would be to use a touchless thermometer. And you got to think about who's going to be administering this screening. That person needs to have appropriate PPE, most likely, to make sure that we're protecting the person who's administering it. And then we need to decide, what are we going to do with this information? If are we going to record every employee's temperature every day? Do you only record the employees who have a temperature, and then that triggers some type of protocol? Because all of the information that we are collecting needs to be maintained just like we would treat any other employee medical record, which means that it should be kept separately. It should not be stored in the personnel file, but in a separate medical file. And we need to be careful with how we treat that data. So think a little bit about those things if these are some of the measures that you are going to be considering implementing. In terms of requiring COVID-19 testing, and I'm going to talk a little bit about that. Again, this is something we can do it. And when I say we can do it, what we can do is we can require an employee to provide a negative COVID test as a condition or upon returning to work initially, right? I'm not talking right now about people who have tested positive, we have sent home, and then they have been released to return and requiring it then. I'm going to talk in more detail about that a little bit later. I'm just talking about, in general, say, we're reopening the workforce, can you require a COVID test? You can. Antibody tests, however, should not be required. The EEOC has told us that it is okay to require a test result that detects the presence of the virus. And that's what I'm talking about when I say COVID-19 testing. That is very different right now from the antibody tests that are out. We don't know how reliable those are. The EEOC does not, has basically said, we don't think you should use them because the CDC has said that cautioned employers against using them. And so that's the current guidance that we have on the difference between the virus test and an antibody test. And the difference between the two is that the virus test detects for the presence of the virus itself, whereas the antibody test is going to tell us if someone has already had the COVID-19 and has developed antibodies that would provide some level or measure of immunity, the extent to which we're not really sure of yet, but that's the general difference between the two types of testing. So this is quickly becoming a very hot topic. And what do we do if an employee, if a customer, if a visitor doesn't want to wear a face covering in our business, in our facility, and how do we respond to that? I was on the phone this morning with an employee who was dealing with this, or employer who was dealing with this issue, and so I know that this is quickly becoming also a political issue, which also doesn't help us when we are business owners and employers trying to manage risk and trying to keep our employees and our other customers safe. So I'm going to preface my guidance here on that fact, and I've kind of tailored it to address that, right? Because I think we have to recognize when we are dealing with these issues that this is a sensitive thing. And I think I think everyone has seen the video circulating on the internet about how out of hand this is getting, and you don't want to be the business who has, the person with their cell phone videoing your supervisor, getting into an altercation with some type of guest over this issue. Okay, so I think we have to be mindful that we are living in the day and age that we are living in, where everyone has a cell phone, and this is becoming such a hot issue that we have to tailor our responses to this a little bit. So I think the easiest way to do this, and again, this is going to depend on the type of business you are. Are we talking about a customer? Are we talking about an employee? What are the specific circumstances? And in all cases, your response needs to be tailored by those. But generally speaking, I think approaching let's just talk about a customer first, and then we'll talk about an employee. Approaching the customer, what's the reason for the refusal here? And I think regardless really of, if the response is, well, I don't like it, I don't want it, I don't want to wear one, then I think we're not just telling the customer this is our policy and all guests need to wear one and we've supplied some for you is a very good, response, first level response. I think hopefully most people will be willing to accommodate that just when we politely remind them that this is our policy and this is what everyone needs to do to enter the business. Now, if they cite a medical condition, they say, I can't do this for a medical condition, or I have some, now we have also religious, reasons that have been cited, or I feel like this violates my free speech. Here's the thing, regardless of the reason and regardless of whether or not, these things are true, I think we should attempt accommodation when necessary. We shouldn't be asking people to provide us with doctor's notes to substantiate their medical conditions. We do not want to get into a political discourse with them about whether or not this violates some personal liberty, although you will see that I have linked here at the bottom of this slide what I think is a very good Tennessee Attorney General opinion on this issue that just came out in the last couple weeks. And the strong conclusion reached there is that this is not unconstitutional. It is not an infringement of anyone's free speech rights, but I don't think we want to get into that, generally speaking, as a business. I think, to the extent that we can try some type of accommodation, offer some type of accommodation, that's the way to approach these situations. Because we don't want to get into that with our customers. So alternate face covering, curbside pickup, having them come at a different time. If video conferencing or remote appointments are available, then that is something that we can offer as well. But that's, I think, the way I'd like to see these approached from a customer perspective when possible. For employees, we have a little more leeway. I mean, for one, if it's a medical condition, then we need to be handling that through what the ADA, the Americans with Disabilities Act, refers to as the interactive process. And that is going to require first medical documentation. Okay, we're going to need something from a physician, and in some cases, you're going to want to be specific with that employee, or maybe even provide them with something that their doctor can fill out that says, I need, here's what the essential functions of the job are, here's what the responsibilities are. Because what I'm seeing right now is, in this example from this morning, the doctor sends in a note and it says employees are unable to wear face masks due to asthma. Please accommodate. Well, as an employer, that doesn't tell me what I need to know. Unable to wear it at all, unable to wear it for 5 minutes, because even if we can put this employee in a separate office where, the employee would not be in a position where they would have to wear a face mask, that employee is going to want to go to the bathroom. They're going to be, going through hallways to get to things. They may need to go to pick up, some materials or equipment, or get their lunch and microwave it. So, really what we need to know is the time, how can they not wear it at all? Can they wear it for short intervals of time? Can they wear an alternative face mask, like a face shield or something? And that would be acceptable. So it's going to be based on the underlying health condition, and then what the doctor says, before you can be in a position to then decide and determine with the employee, how can we accommodate you? And here are some options. If the person can telework, that's great. An alternate work schedule, maybe you put them in a non-public facing position, if that's an option. And don't forget that under the ADA, offering unpaid leave is also another form of an accommodation. So, again, I think the attempting accommodation, and I think that's also something that can be said for a lot of the issues we're going to talk about, right? There are some gray areas in this. Everyone is navigating it together and trying to do the best they can. And I think we need to be, as businesses and as employers, reasonable to the extent we can, even if it's a situation where maybe the law doesn't absolutely mandate us to do something. I think employee morale, customer morale is an important thing, and to the extent that we can, make accommodations and still keep everyone safe, then that's what I would encourage everyone to be doing in this situation. Because I also think that it mitigates risk. That customer that you offer to deliver something to, as opposed to refusing service to, you may find that those two situations play out very differently. And so that's, one of the reasons I kind of recommend this approach. And similarly with employees, it is another one. So just kind of overarching issues on face masks. So what steps should businesses be taking if you have an employee who tests positive or exhibits symptoms of COVID-19? And the first thing that we need to do is determine if we need to clean and disinfect. And again, there are CDC guidelines that are out there on that. This is going to depend whether or if you need to do this is going to depend on when was the last time that the employee was in the facility. And so determining that, determining if cleaning is needed. I believe that the guidance on that is if they were within the facility anytime within 7 days of them testing positive or for COVID-19 is what the current guidance is on that. But again, it seems to be changing. And so I would, if you have that situation come up, I would double check the CDC's website to see if that guidance has changed. In general, you're also supposed to wait 24 hours if possible before you allow anyone to go into that space to clean. And the cleaning, again, is going to be the areas where the employee was in, for some length of time, not the entire facility. As long as the employee can tell you, here's the areas I was in, then if that applies, that's something that needs to be done. And again, in some instances, we may need to keep other employees from going back into that space until that cleaning has been done. That's also going to just make everyone feel a little bit different, right? If we have one of these exposures and we say, listen, we've had an exposure, we're going to do this deep cleaning, we'll let you know when you can return. That's something to keep in mind. Again, this is going to be different for every type of business, and in some businesses, this may not be possible. So remember, the CDC guidelines are not legal requirements, but they do establish sort of best practices. And I think that if you are doing what you can as a business to comply with those when necessary, it's going to be more difficult for someone to say that you were somehow negligent and failing to do what you should have been doing. So the second thing that's going to need to happen when an employee tests positive is for you as the employer to determine the other employees within that employee had close contact with. Close contact is a term of art. So what do we mean when we're talking about a close contact? The current guidance on this is that anyone who was within 6 feet of the employee for 15 minutes or more during the 2 days prior to the onset of their symptoms or the positive COVID test, whichever is earlier. This is irrespective of whether everyone was wearing a face mask. So again, I'll go over that one more time. The close contacts are going to be anyone within 6 feet of that individual for 15 minutes or more during the 48 hours before the onset of their symptoms or the positive COVID test. So once we identify who those individuals are, which is going to start with a phone call, a conversation with our employee, ask them the areas they've been in, ask them the individuals that they were in close contact with, and make sure you explain to them what that means and not leave that to their own interpretation of what close contact means. So I would be specific with it. Those individuals that are identified during that contact tracing process have to quarantine for 14 days at least since their last exposure to that employee. And I'll go into a little bit of what I mean by at least there. The new guidance from the CDC's website has now changed. And it's in this scenario, what we're talking about now, we are assuming that that individual who quarantines goes home, has no more exposure to someone who has tested positive or is exhibiting symptoms. And if that is the case, then once those 14 days are passed, that person has no symptoms, they feel fine, they're okay to come back to work. We don't need to require a doctor's note. They were never sick. The reason they are quarantining is because they could have possibly been exposed to someone who had the virus, and that is the incubation period for the virus. So essentially, they're not sick. We don't need to ask them to go to the doctor. Lord knows our doctors are overwhelmed as it is right now, but we do need them to go home for 14 days. And the only situation where that 14-day period would change would be if the employee starts to have symptoms or if the employee is exposed to someone else with symptoms. Say employee goes home and his or her son or daughter or spouse or partner contracts COVID. Then at that point, the guidance on when that isolation can end is different. And again, that is it's basically the 14-day quarantining is based on the length of time since your last exposure to someone who has contracted COVID. So if it's a spouse, you guys have a big house and you guys can go to different rooms and not see one another for 14 days, then it's the 14 days. But if it's a child, if it's someone you are caring for someone with COVID, then it is a longer time period and it is based on that individual's recovery, essentially. And so the CDC website is great. I think it is going to be a lot of our new best friends. We need to put it on our favorites and check it periodically and routinely, especially if you do have one of these incidents come up, because again, this guidance is constantly evolving. And this is what it is as of yesterday, as I said. Critical infrastructures are a little bit different. The rules for them are a little bit different. And again, when I say rules, I'm talking about what the CDC says is okay. You as an employer are always free to say, yes, I have employees who may fall into critical infrastructure workers, but I'm going to follow the guidance for everyone else, okay? You're always free to adopt more strict standards as an employer, and so just remember that. And so, critical infrastructures are, what we've been referring to as our essential employees, okay? The people that are in industries that are considered to be essential to continued critical infrastructure viability. So the guidance for these folks changes a little bit. These are our, the grocery store workers, the first responders, the individuals, the healthcare workers, and in fact, teachers are another, category that falls into this bucket potentially. For them, again, CDC has a different rule for them, because if they all went home every time there was they had exposure to a confirmed case, we would have serious issues as a country, maintaining our essential services. So for them, they can be continued to work after potential exposure, but they have to remain asymptomatic, and there are some additional precautions that have to be implemented, during that time period where they would otherwise be quarantining.
Hey, Emily, this is Carolyn. I'm sorry, I was going to jump in. We've got a couple questions, and I'm
Sure.
going to keep most of them for the end.
Okay.
But one of them was specific to that slide, and
Yeah.
I'm curious just if you're familiar, but in reference to the contact of 15 minutes or more, is that 15 minutes, is it considered consecutive? Is it cumulative? I'm not really sure.
Right, that's a great question, and that's a good thing to keep in mind, because here's what we're doing. Generally speaking, this is going to depend. Now, if someone saw someone throughout the day for multiple periods of 5 minutes, and they were there, 5 to 10 minutes, but they saw that person, 5 times that day, I'm going to say, let's go ahead and have that person quarantine, right? Because it's all about trying to gauge risk of possible exposure. We know that this virus transfers, mainly through respiratory droplets. And so if you have someone who you're like, I think they're on the edge, it wasn't 15 minutes or more during one occasion, but cumulatively during that 48-hour time period, they spent a lot of time together, go ahead and have that employee quarantine, because this is one of those areas that is better to err on the side of caution, I think. Is there another question, Carolyn, that you want to?
Great. No, thank you for that. I've got one more, and I've seen a couple of different things. This has come up when we do our healthy business certification, but this question relates to this slide as well. What if the employee does get tested and they end up with a negative test result within that time that's less than 14 days? Right.
So the problem with that is based on the incubation period for the COVID. Now, if the 14 days are up and you want to have them produce a negative test, I think that's perfectly fine. Again, remember, testing needs and capacity vary throughout the state, right? So in Davidson County, you can go and get a test, but it's also going to be some areas they won't even give you a test if you don't have symptoms. So you got to be familiar with where you're at in the testing availability in your specific community before requiring or imposing that requirement. The reason that you can't require that, say they have to quarantine and they come back 2 days later and they have a negative test and they just went and got it and it's within the past 2 days. This is why the incubation period for this virus is so important, because someone can test negative and yet still have it, it's just not detected yet. So if you want to have someone come back early, really they can't come back earlier according to the CDC. 14 days is always going to be the minimum, assuming there was close contact, unless they're an essential worker. But if you want to require that at the end of that quarantine period, if testing supplies are available, if that's something that is feasible, then you can do so. But doing it any sooner than that 14-day period is not going to help you because it may not detect the virus, essentially.
Great, thank you. We definitely have a few more questions, but let's jump back to you because I know we're almost at 10:45, so we want to give you the time.
Okay, all right. Okay, so I'll try to kind of move through these and leave some time for questions. So, and again, this is something that when they can come back, this is the current CDC guidance on it, okay? And it's going to be 10 days. And this is the issue you're having with employees right now. So you have someone who's positive who can come back sooner than someone who was possibly exposed. And the answer to that is yes. And it's because of that incubation period that we just kind of went over. And so that may change, but this is where we are at right now on when someone can come back in the guidance for that. You can consider more restrictive measures, and I talked about some of those. The one thing we shouldn't be doing, and I do want to touch on this because it has changed and it is new, is that we shouldn't be requiring employees who tested positive to give us a negative test when they come back. And the reason for that is CDC at one time recommended a test-based strategy. They have since changed those recommendations. And so that is something to be mindful of. The reason for that is that we're finding that some people can continue to, the viruses continue to be detected, so they will test positive for up to weeks, 6 weeks, 8 weeks after the fact. And yet they are not contagious. The health, public health officials feel confident about that, and so there's no reason for requiring a negative test for them. So that's something that's changed, so I wanted to point that out. As we head into flu season, cold season, also remember we may have people with symptoms, but there's some other reason, and so if your policy doesn't address that, think about that. And we can be limited with that, things like strep throat, and you have a confirmed, positive strep test or something. There may be different return to work procedures for those employees, or err on the side of caution, treat everyone the same, and follow those more restrictive rules for them. This is just one example of something you can use on, whether or not to require documentation based on the specific situation here. Do we have to provide paid leave for these employees, okay? And so I'll touch briefly on this. The one statute that really comes into mind first is going to be this Families First Coronavirus Response Act. There are 2 paid leave provisions under this act that apply in different situations. And this is going to apply to employers with less than 500 employees and some public employers. Both laws are set to expire December 31st of 2020. That's the way it is right now. It could change this week or next week, but that's where we're at right now. The overarching things to remember with this is that the paid sick leave portion of this is only up to 80 hours for a full-time employee, and this is for 6 different specified reasons, but it includes being advised by a healthcare provider to self-quarantine. And I have been advising my clients that I think this also applies whenever we send someone home to quarantine because of a possible exposure. This is a one-time leave entitlement, 80 hours. So even if there's, they have to quarantine this month for one reason and next month for another, it's 80 hours. Once it's gone, it's used. The EFMLEA Leave Act is a type of FMLA leave that is somewhat paid, and this is really only for employees who are unable to work because of school or child care closure. That's up to 12 weeks of leave. Again, if you think I have less than 75 employees, FMLA doesn't apply to me, you are subject to this. So look at these 2 things, especially if you've been, if your workforce has been remote. Now that people are going back to school, I expect we will start seeing more requests for this EFMLA leave. And there are, if you're not familiar with that, then definitely needs to be on your radar. Other possible leave entitlements. Now these are all, ADA and FMLA are all going to be unpaid. So keep that in mind. Tennessee, we don't have any mandatory paid sick leave laws or anything like that, so we don't have to be concerned with that here. But you do need to look at your existing employer leave policies and what do those provide for. And is there paid leave entitlement under that through PTO or some other type of policy. For employees who do not have COVID but are just afraid to return to work due to underlying health concerns, that really needs to be dealt with under the Americans with Disabilities Act. And it, again, is similar to what we talked about with the face mask policy, okay? And how do we accommodate those individuals? If there's an underlying health condition, we need to be mindful of that. We need to be going through the interactive process. This does not necessarily apply just to someone who is 65 years or older, because that is not subject to the Americans with Disabilities Act like an underlying medical condition would be. But that is one of those scenarios where I think, even though the law doesn't require it, let's attempt accommodation when possible, because that's the way to keep your employees healthy, to keep them happy, and to keep you out of litigation over something like this. It's also important to note that we should not be making assumptions about these people. We should not be individually reaching out to, Johnny, who has a health condition or a heart condition, or Susan, who has diabetes. Let these individuals come to you. I think some type of a general announcement to employees that says, we're returning, here's our protocols. If you have concerns, please reach out to designate the appropriate person to have those conversations. But otherwise, we don't want to target these individuals, because doing so makes it seem as though we are regarding them or assuming they need an accommodation. And even though we may be doing so out of the kindness of our hearts, it can get us into issues. So this is more on some potential accommodations. We talked about a little bit about those earlier in terms of job restructuring. Telecommuting is a great thing. Here's the other thing. This might be as simple as giving someone a different office. If you can give them an office that's separate, apart from someone, things like that may make someone feel more safe, and may be a form of a reasonable accommodation. This is kind of an overview of the best practices. I think we've talked about each of these during this presentation. And then I'm going to touch briefly on this litigation, and then we can get to some of these questions. So, remember here that, our other employment laws don't go away during this time period. We still have to be mindful of things like a retaliation complaint under OSHA. Someone feels as though it's an unsafe working condition, work environment, and they make some type of a complaint to OSHA, which there have been a lot of lately. That's okay, but if that employee goes out and they post on social media and they say, my employer is doing a terrible job and it's unsafe and no one's wearing masks and I feel bad, and then we terminate that person, that's going to be a pretty clear retaliation claim under OSHA and the NLRA. So we got to remember that in this environment, people voicing concerns about workplace safety, workplace environments can be protected speech, and we have to be mindful of how we treat those things. Similarly, when we're talking about furloughing or rehiring or elimination or granting certain accommodations, we need to try to always apply those decisions and always base them on things that are driven by the position at issue and based on legitimate non-discriminatory factors. We need to be able to point to what we've talked about. Is it tenure with the company? Is it experience? It needs to be something that we can go back to, because the second we start treating people differently, we open ourselves up to discrimination claims. If we let one person in a position that is similar to another, telecommute, and then deny someone else's request. If the job requirements don't allow for that other person to be able to telecommute, then that's fine. But if they both do, we better think real long and hard before we start granting those types of requests for some employees and not for others. Liability waivers. This has been a hot topic. It's something that many businesses are doing. I think for customers, it's certainly okay. For employees, again, and this is where the workers' comp comes in. Generally speaking, our workers' compensation laws are very strong here in Tennessee. it is going to be very difficult for an employee to bring a cause of action against you as an employer if they contract COVID, if they die from COVID, and their family tries to bring some type of action because of your workplace environment or alleging that you were negligent in failing to protect them from this stuff, okay? We have in Tennessee what is called the exclusive remedy rule. Means the exclusive remedy for those types of claims is workers' compensation. And yes, you may have some workers' compensation claims related to that, but it's a lot better than defending those claims in court, whether that's as a class action or as an individual claim. This is exactly what we created our workers' comp scheme to address. So, you know, do everything you can, but, you know, you sleep at night knowing that if we do unfortunately have something like that where, you know, that comes into place, you know, we have that protection, which is why I don't think you need a liability waiver from your employee. It's probably not going to be enforceable as it is. What I have been doing and recommending is some employees to sign acknowledgement forms, acknowledging, you know, I agree that my decision to return right now is voluntary. I will comply with the safety policies and protocols that we've put in place. I understand what those are. I will not report to work if I have symptoms or if I test positive, stuff like that. I think that can be helpful in these scenarios. And again, you know, we always have the possibility of legislative action on the horizon, both at the state level, federal level. Unlikely that those types of things would be retroactive, but that's another, you know, possible protection that we are going to have. Just from a general standpoint, I think causation in these cases is going to be very difficult. You know, unless you have, assuming there was some type of real liability there, unless it can be proven to be attributed to the workplace or the business. And I think that's going to be hard in a lot of these cases. And then again, showing that the business did something wrong. So that's just a brief, I know I kind of rushed through this last half of this, but I wanted to leave time for some of these questions and to be able to get to those.
Awesome. Yeah, thanks, Emily. We do have quite a bit of questions, and I think we've still got just a huge crowd. So if you're good to answer questions, I'll be happy to ask them.
Sure.
And I'm kind of working my way through the chat and the Q&A. So if anybody else has questions, please send them and we'll get to them if we can. Do you have a link that you might recommend that an employer could provide an employee a form for medical needs accommodations? Is there any kind of site or where you might recommend?
Right. Are you talking if you're talking about a template, like
Yes.
Yeah, I would be happy to email that. I have a template that I use now. It might need to be tweaked, but I'm happy to provide that to you, and you can distribute it to the people that are on this webinar.
That would be so helpful. Yes, thank you.
Sure.
Next question we've got in here from Jeff in Blount County, which thanks for being on, is about traveling. So what about if an employee travels to a state? We've all seen some of the states have high COVID numbers, and specifically with it being the summer, I'm sure Florida has obviously been one of those.
Yep.
Or would that employee be required to quarantine for a certain amount of time?
Right. So you need to take a look at your travel policies. That is certainly something a lot of employers are implementing, and it is reasonable to do it. And you know, all I would say with that is provide advance notice to the extent that you can, and put it into a policy, and put it in place, and then rely on it. You know, I think the harder thing is going to be what qualifies as a hotspot right now. You know, I would say that Nashville's one of them, potentially, right? So it's also what more, yes, you can do it. Think about how you do it and how you determine, you know, what areas you're going to want to impose those requirements for. And if you are going to impose a requirement, I would stick to the incubation period, the 14-day incubation period, because anything shorter isn't going to, it's not going to achieve what you're trying to prevent.
Great, thanks, Emily. And like everything is ever changing, obviously the kind of those hot zones are changing. So just keeping up with that.
Yep.
Great. Next question. Can an employee telecommute from home when they're asymptomatic? So under that 14-day quarantine?
Absolutely. If they can go home and they can be working, that's great. That's the best case scenario. And you don't have to pay them in that instance as long as they can work.
Okay, great.
Well, you're paying them to work. You're not paying them to sit at home. Let me correct that.
Right, right. So it says pregnancy seems to not be recognized as high risk. What do you recommend for pregnant employees and how to best handle this scenario?
Right. I think pregnant employees are one of those areas where, if they're approaching us, if they are fearful of returning, then we need to try to accommodate them to the extent we can. It might not be, legally required. We are legally required to accommodate pregnancy-related medical, restrictions. But, this is one of those scenarios where I think, if we can make our employees feel safe, feel a little bit better, and try to work with them, that we should do so.
All right. What are some options perhaps for accommodating if the job in question can only be performed at customer locations and there are no other positions in the company? So if somebody is concerned about returning to work and basically they are customer facing, they're going to be out visiting clients.
So additional PPE would be something we can offer to them, gloves, face shield, plexiglass partition between them and customers. Those are the types of things that we can do, for people that are customer facing. If at the end of that, process, they are still unwilling to return and we've done everything that we can think of, we could offer them unpaid leave as well. So remember, that's always an option in terms of an accommodation. And so, but really our job is to try to, exhaust, what we can identify as something being reasonable. And offer that.
Great. We've got about 3 more minutes, so I'm going to answer or ask you as many as I can, and then we may have to kind of cut it short, but thank you. This is so helpful.
Yeah. And I'm happy to stay on if I don't know how that works, but I'm happy to do that if we want to try to get through them. Or people can email me.
Okay, great. We'll try and get through them all then. Just didn't want to run over into your time. So next question, what if an employee notifies you they've been around someone else who is being tested because that person was around someone else who tested positive? Would that employee need to go home even if the person they were around has no test results yet?
Right. So this is another one where we need to kind of use our discretion. When was that person around? Generally speaking, no. Now, if you want to be uber conservative, I think what we're going to start to find is that at some point, everyone is going to have been around someone who's around someone, who has this. And so, you got to think about it from that perspective too. If we start tracing it out too far, then we're not going to have any employees. So if that person can telework, if you want to be super conservative, then sure, I think asking that person to work from home is acceptable, but it is not required unless that person that they do have close contact with starts to have symptoms or themselves test positive, in which case now they're a close contact.
Great. Next question. Do you believe non-employee liability waivers are necessary?
I think it's going to depend on your business. Listen, waivers they are never bulletproof. In some cases, I have done them for customers, for instance, event venues, right, where people are wanting to have events and congregate in big groups, in certain parts of the state. And I think in those cases, sure, so having someone sign a waiver saying, that we recognize that this is a pandemic, that by being around other people, we are subjecting ourselves to an increased risk. And, now, will those hold up if challenged? That's going to depend. If there's gross negligence involved, probably not. But hey, having something like that in place, if it works for your business, is okay. There's maybe some businesses where the thought of putting that in front of a customer or based on who you're serving, that's going to create more backlash than it would give you protection. But I think it's something to consider.
I think I've even seen or heard of that within like an HOA, basically acknowledging that your community amenities might put you at risk for exposure.
Which I think is listen, it's not to say someone could never challenge it. Also remember, in Tennessee, you can't waive your child's claim for a minor, but it's definitely, and that's a great example of something where I wouldn't hesitate to use that.
And then a follow-up question to that just came in is, what if your employee signs another waiver and attends such an event?
Right, right. So this is the harder issue, which is we can do everything so perfectly and be so careful in the workplace, but we cannot control our employees when they leave our workplace. And I see this being a huge issue, especially with our younger millennial and after that employees, even younger employees, is doing that. Some of those acknowledgement forms that I've put in place for other clients have included things like, I recognize I should not be in, groups of more than 25, and I'm going to try to abide by things. The truth is, we can't control what they do, and you may see people social media activity. Now, if you want to ask them to quarantine, you can, but generally speaking, I like to try to stay away from regulating our employees' private lives. Now, here's a very different scenario. If that person is a nurse or in a healthcare setting or works in a nursing home, then I think at that point you're right to kind of be involved right now as an employer. You have a little more leeway in what you can require, just because of the risk that person would pose to the people in that facility coming in. But it's a gray area, and it's a hard one, and I'd say it's going to depend on the business in terms of how you handle that.
Now, certain questions do seem very gray. I know there's a lot of, depending on the industry you're in as well. So I have kind of a two-part question. Someone had submitted that if you can social distance in your factory, do you have to wear a mask? And then in relation to that, are you aware of any situations when businesses have been asked to enforce the face covering requirements?
Right, it's happening more and more in terms of the enforcement. And again, I think about this from the standpoint of if you aren't doing it, and there is a face mask requirement, then what could the potential backlash be? And again, I've said our workers' comp, protections are very strong here, but we want to be following that bar that is set by whether that is state health officials, local health officials. And the guidance that's out there. And especially if you're in a facility from just an OSHA standpoint too, we have to remember that. So, the guidance I'm hearing is that, we should all be wearing face masks. What we're doing, if your business allows for it, they're not required if you have an individual office or you're in your own separate space. But the second that you're in a common area, they need to be worn. And I think that strikes the right balance for those places where, social distancing maybe is possible. But I also think if it's just one large room and it's not something where someone can go and shut a door or is in kind of a confined cubicle space, that you need to be more probably more cautious before you decide not to require the face mask, just because of what we know about how the virus is transmitted.
Okay, great. I've got just a couple questions left. If an employee has a family member with COVID and have recently been around them, do they need to quarantine even without symptoms? And I think you might have this, but okay.
Yeah, yes. And the length of their quarantine is going to depend on whether they can distance themselves from that individual or whether they can't, which may depend on their living arrangements. Can someone sleep on the couch if it's a spouse? But if it's a child and you're caring for that child, it's unlikely you're going to be able to stay away from them. And in that case, it's a longer period of quarantine, and it is driven by when that person recovers, essentially. I think it's 14 days from the date they recover, but that is on the CDC's website.
Great. For those essential workers, what extra precautions should they take if a worker tests positive?
Right. So there is specific guidance, again, on the CDC's website for the procedures and precautions that should be taken for those workers. I believe, off the top of my head, it involves things like a health screening questionnaire every day, temperature screening every day. Monitoring them more closely, because if they start to have symptoms, then they need to go home. But those are all outlined on that page.
Great, and I will try to find that link. I've tried to keep up with you, Emily, as you've shared some and put those in the chat. So hopefully that has been helpful. Kind of two final things. This is a great question, and I'm curious to know what your response will be. Does previously having COVID, would that qualify someone as having an underlying issue, or is it too early to know?
Right. Here, it's too early to know. I think what we're going to see a lot of is that the person has COVID, and because of an underlying health condition, now that person has a serious health condition that might entitle them to something like FMLA leave. Certainly, because it's a gray area, we should treat it like we would in terms of providing the accommodations. It may not be a disability. The flu is not, for instance, normally considered a disability, but because of that, it can trigger people with more serious underlying health conditions to really have problems, and then it's absolutely protected. So that's what I would say about that.
Great. Well, I'm going to kind of wrap things up. I know we're a few minutes over, and this has been so helpful. I know there's still questions coming in, so we will make sure. Emily, I believe you're open to people emailing if they have a follow-up.
Sure.
Okay. And I'll be happy to help facilitate anything that we can through the chamber as well. I really love this question that came in. It says it's not a legal question, so I think it's a great one to end on. But any ideas to reward essential employees who have worked tirelessly throughout the pandemic? So would love your feedback, and then also anybody that's on today's webinar, if you have ideas and want to email those to the chamber, we would love to hear them. So
yeah, I mean, people love money. Hazard pay is a big topic right now, whether or not that's required. But even if it's a bone in the form of a bonus, in the form of a discretionary bonus, so we're not obligating ourselves to it, that may be the best. Providing additional paid leave, so those people can also have time to take off is another possible things. But those are the two things that come to my mind.
Hi, and this is Susie. Just in direct correlation to all of this, just wanted to encourage those to check out our website and that offering that the Tennessee Chamber has been offering the past few months, the Healthy Business Certificate offering. It's on our website. Would encourage you. It has a lot of answers. It's a 3-hour certification course, but would encourage you to look at that. And we really appreciate you, Emily. This has been such a great offering, and we appreciate your time today.
Yeah, thank you for having me.
Yeah, thank you guys. And just as a follow-up, once again, so many questions. And Emily, this is so helpful. Thank you. We will send out the recording, and I believe, just to confirm, we can share the slides. I know a lot of people have asked. Great.
Sure.
And Emily's contact information will be on that, as well as the follow-up email. So thank you all so much for attending. We had 100 people on here, so a hot topic, and we cannot thank you enough. So we'll send a follow-up email by the end of today. And Emily, thank you again, and Burr Forman, for your time.
Thanks so much.